Remember the customer client from Ohio in the previous lesson that called about a property? You have never met them face to face. You have, however, discussed a particular property over the phone. Well, what do you do prior to them coming here to Arizona? You share documents like the REAID form and the BBEA with them. Engage in a conversation about agency as if they were present in person. Guide them through the process of electing buyer's agency and dual agency, ensuring they sign and date the form before sending it back to you. Upon their arrival in Arizona, when you pick them up from their hotel, ensure that the signed form is already in your records. This signifies the establishment of a client relationship, indicating their choice for you to represent them in a specific manner. Failure to complete this process might still create an agency relationship, likely in the form of implied agency. If that is the case, they could go off and use any other agent, and you would have no recourse to be paid a commission. You should also have a conversation about whether they are going to be obtaining a loan and what kind, or if it will be a cash purchase. Determining when the seller becomes your client is generally clearer. When a seller explicitly requests your services for listing their property, initiate the agency discussion and have them sign the READ form. Sellers typically have two options in terms of agency relationships: represent the seller as a seller's broker, or represent both the buyer and seller as a dual agent. When dealing with sellers, it is evident when they seek your client services. Having this discussion and obtaining their signature on the REAID form at the listing stage clarifies the agency relationship. Sellers usually anticipate dual agency, especially if you've promoted your affiliation with a large firm. This alignment is generally well received, as they expect your firm to handle both the listing and potential buyer representation. Let's examine some of the challenges agents face when they fall short of providing sufficient agency disclosure. In most cases, the absence of a proper agency disclosure itself may not lead to immediate consequences. Buyers and sellers typically don't immediately take action against an agent or broker solely for deficient agency disclosure. Problems usually arise when a transaction goes awry, such as a misrepresentation of property defects or issues with easements, leaving the client feeling aggrieved. Whether justified or not, the client might consult an attorney to explore the possibility of legal recourse against the agent and/or broker. During this consultation, the attorney will scrutinize the details, review all documents in the file, and assess the merit of pursuing legal action. If a valid agency disclosure aligns with the contract disclosures, the attorney is less likely to pursue an agency-related claim. However, if the agency form was never completed, or the client is confused about representation details, the attorney may include a claim for failure to adequately represent the client. In Arizona, Statute ARS 322153.1 empowers the commissioner to revoke a license for failing to promote and protect the interests of a client. This charge becomes even more serious when a client is uncertain about who represented them and how it was done. Therefore, the primary objective should be to advocate for and safeguard the interests of clients, ensuring clarity in how representation will occur. Clients should sign the REAID form to confirm their understanding, and consistency in agency disclosures is crucial. Any inconsistency between the REAID form and the contract could potentially lead to complications. A frequent error in the process of agency disclosure and confirmation is often found on page 9 of the Arizona Residential Real Estate Purchase Contract. On this page, the buyer's agent inserts the buyer's information at the top, including their name, address, company details, contact email, and phone numbers. The agent then designates whom they represent by checking a box, with the buyer signing below. Upon presenting the contract to the listing agent, a similar procedure occurs in the middle of page 9, specifically in Section 9A. Here, the listing agent inserts their client's information and designates their representation by checking a box, followed by their client's signature. This common mistake typically arises when an agent, who has been working with a buyer and showing various properties, finally identifies a listing within their own firm. Despite knowing that this scenario results in dual agency, the agent may either forget or misunderstand the implications. Consequently, they check the box representing the person they are assisting, leading to confusion. In the ensuing transactions, the buyer asserts that the agent represents them, while the seller's agent claims representation of the seller. Both parties, however, write the name of the same company, broker, in their respective sections. The contractual documents are signed, and the process continues until the broker reviews the file and recognizes the error. The broker will then decide how to proceed, but the agent's failure to execute a valid agency disclosure becomes evident. Regardless of previous agency-related actions, the contractual mistake contradicts the dual agency established and may pose a problem. It is crucial to note that in Arizona, agency authority emanates from the designated broker of the company, not the individual agent. Whether the broker oversees one office with 10 agents or 30 offices with 4,000 agents, engaging in dual agency occurs when one agent sells another agent's listing in the same brokerage. Agents should engage in a conversation about agency with clients and share documents like the READ form. Let's explore various scenarios that illustrate the concept of agency. Consider broker Bob, who serves as the designated broker for Bob's Realty. Managing 5 offices and overseeing nearly 200 agents, Bob encounters a situation where an agent from the Tucson office sells a listing from an agent in the Marana office. Despite the geographical distance, this still constitutes dual agency, as both offices fall under Bob's brokerage. Whether these offices are miles apart or located on opposite ends of the state, any cross-sale under Bob's oversight would qualify as dual agency. Dual agency occurs when a single real estate brokerage or licensee represents both the buyer and the seller in the same transaction. When a franchise is involved, like Century 21, RE Max, Keller Williams, etc., the situation can become more nuanced. Here's how it works. What is a franchise in real estate? A real estate franchise is a national or international brand, e.g., Coldwell Banker, that licenses its name and business systems to independently owned and operated brokerage offices. While these offices share branding, they are separate legal entities. Dual agency in a franchise setting. Even though offices are independently owned, dual agency can still arise under certain conditions. 1. Same brokerage office. If one office of the franchise represents both the buyer and the seller, then dual agency clearly applies. This can happen if one agent represents both sides, true dual agency, or if 2 agents from the same office each represent a different party, often called designated agency, but it can still be dual agency in some states. 2. Different franchise offices. If the buyer and seller are represented by agents from 2 different offices under the same franchise brand, whether this is dual agency depends on state law and brokerage structure. In many states, this is not considered dual agency because the offices are independently owned. However, some states may still treat it as dual agency if there's a shared broker or corporate ownership. Key factor: who holds the broker's license and supervisory authority? Disclosure requirements. Regardless of the structure, full disclosure of dual agency must be made in writing. Both buyer and seller must give informed consent. Dual agency limits the agent's ability to fully advocate for either party, so clients must understand the implications. Example scenario. Imagine a buyer is working with Agent A from Century 21 Office X. A seller is working with Agent B from Century 21 Office Y. If offices X and Y are independently owned and don't share brokers, this is not dual agency in most jurisdictions. But if both offices are owned by the same company or supervised by the same broker, it might be dual agency. Takeaway for agents. Know your state's laws on dual agency and brokerage affiliation. Always clarify the ownership structure of franchise offices. Disclose and document agency relationships early in the transaction. You can use this to help clients understand what dual agency means in a franchise setting. Although our company operates under a national brand, our offices are independently owned. In this transaction, both the buyer and the seller are represented by agents who work under the same designated broker. Arizona law requires that we disclose this dual agency arrangement. As dual agents, we cannot advocate for one party over the other and must treat both parties honestly and fairly. You must both consent in writing to proceed with this arrangement. It's important to note that agency structures vary among states. Some states adopt a single agency, or agent agency, model where the agency relationship is defined by the individual agent. Arizona, however, is not currently inclined to transition to either an office agency or single agency model in the foreseeable future. Confidential information remains confidential. After termination of agency relationship. The broker listed a property for the seller, but was unable to sell the property. When the broker's listing expired, the seller relisted the property with another brokerage firm. The broker possesses confidential information about the seller, which was acquired while the broker represented the seller. May the broker disclose confidential information about the seller? Arizona courts generally follow the restatement of law if its view is logical, furthers the interests of justice, is consistent with Arizona law and policy, and has been generally acknowledged elsewhere. Ramirez v. Health Partners of Southern Arizona, 193 Rs. 325, 972, P2D 658, Apper 1998. Pursuant to the restatement, second, of agency, paragraph 396. Using confidential information after termination of agency. Unless otherwise agreed after the termination of the agency, the agent, B, has a duty to the principal not to use or to disclose to third persons, on his own account or on account of others, in competition with the principal or to his injury, trade secrets, written lists of names, or other similar confidential matters given to him only for the principal's use or acquired by the agent in violation of duty. The agent is entitled to use general information concerning the method of business of the principal and the names of the customers retained in his memory, if not acquired in violation of his duty as agent. D, has a duty to the principal not to take advantage of a still subsisting confidential relation created during the prior agency relation. Emphasis added. The comment on subsection D of paragraph 396 also states in pertinent part that one who customarily buys or sells property through a broker can properly assume that the broker will keep confidential information given him in matters connected with dealings in such property, although not in connection with a transaction in which he is employed. Therefore, the broker's duty of confidentiality to the seller would preclude the broker from disclosing confidential information about the seller even after the termination of the agency relationship, unless the broker obtains the seller's consent. The best policy is to treat others as you would want to be treated and to be honest in all your dealings. In Arizona real estate, even after the termination of an agency relationship, certain confidential information must remain protected. This duty survives the end of the relationship due to fiduciary responsibility and is grounded in both common law and Arizona Administrative Code, AAC R4 28-1101F, which states, "A licensee shall not disclose confidential information without the written consent of the client except as required by law." Examples of confidential information that must remain confidential after termination. 1. Client's financial information. How much a buyer is really willing to pay. How little a seller is willing to accept. Pre-approval or financing details. Creditworthiness or income documentation. 2. Motivation for buying or selling. Divorce, death, job relocation, financial distress. Must sell quickly, or desperate to buy before school starts. 3. Terms of previous offers. Offers the client considered or rejected. Concessions they were willing to make. Strategies discussed during negotiation. Negotiating position. Limits of flexibility on price, repairs, or closing costs. Internal discussions on negotiation strategy. Willingness to waive contingencies under pressure. 5. Future plans. Plans to buy another property. Intentions to lease back, subdivide, or develop. Future business ventures involving the property. 6. Personal information. Family dynamics, e.g., divorce, illness. Immigration status or sensitive employment details. Legal or financial disputes related to the property. What an agent can disclose. After termination, with caution. Some information becomes non-confidential if the client authorizes it in writing, or disclosure is required by law, such as material facts affecting the value or condition of the property, e.g., known defects, lead-based paint hazards, environmental issues, HOA restrictions. Note: the duty to disclose material facts to third parties overrides confidentiality, even after the agency ends. Best practices for licensees in Arizona. Always treat client confidentiality as permanent unless consent or legal necessity overrides it. Avoid casual conversations or war stories that may unintentionally reveal past clients' private matters. Keep records secure, even after closing or termination, and dispose of them according to brokerage policy and Arizona law.